Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin. I'm the managing associate of our Calgary office. I'm coming to you today to discuss with you your employment law questions. If you have any questions related to your employment, feel free to ask them in the chat. I'm here for the next half hour to answer all your questions. Once again, thanks for joining, and feel free to put your questions in the chat. We'll get to as many of them as we can today before we all head off for the long weekend. While we get started here, I wanted to talk to you about a subject that keeps coming up in my practice, something called frustration of contract. So frustration of contract, what that refers to, that's a method that an employer can terminate an employee without providing any severance. So because it allows the employer to terminate an employee without compensation, employers can use it quite a bit. And they've been using it in the context of the COVID-19 pandemic. Essentially, frustration of contract means that despite the employer wanting to employ the employee and the employee wanting to work, the situation has become that the contract is impossible to perform. The employment contract is impossible to perform. Imagine a scenario, for instance, where you work for a cannabis shop, and tomorrow the government decides that selling cannabis is illegal. So even though you want to work at the cannabis shop and the employer wants to employ you, the job now is illegal. So in that case, no severance is owed. The contract has been frustrated by operation of the law. It has become impossible to perform. Now, in the context of COVID-19, there was a huge, as everyone knows, a huge economic drop, and a lot of companies were affected by that. Travel, hotels, restaurants, etc. Really, no sector was spared, and so some of the employers in these sectors are saying, "Well, it's not that we terminated you; your contract was frustrated, so we don't owe you severance." So the thing about frustration of contract, it's very hard to prove. So if you see that coming up in a termination letter or something like that, feel free to reach out to us. When frustration of contract occurs, it has to be something that's completely unforeseeable and it completely changes the nature of the contract. So yes, COVID-19 might have been unforeseeable, but an economic downturn is not unforeseeable. So just because business went down by 10 or 15 or 20 or 30% or 50%, that doesn't make the contract frustrated. Essentially, for the contract to be frustrated, it has to be unforeseeable, and an economic downturn is not unforeseeable. So before you walk away from your severance because your employer is claiming frustration, be sure to reach out to us. You can reach out to us at employmentlawyer.ca. That's employmentlawyer.ca, and we'll be happy to speak to you to let you know what your rights are in that situation. I have a question coming in here from Teresa Aguilar. Am I able to get severance pay if LAUSD terminated me because I did not take the COVID-19 vaccine? So I'm not sure who LAUSD is. Essentially, generally, what's happening in these cases because of the COVID-19 vaccine is that employers are claiming they had cause to terminate the employment of the employee. It really depends on the context of the workplace. So if you're working from home, for instance, there's no way the employer should be able to force you to take the vaccine. If you're working in other more high-risk areas, there could be an argument to be made, but a lot of people are being placed on leave or are offering to, do rapid testing or things of that nature, wearing a mask, continuing to socially distance, which makes it harder to argue that they were entitled to terminate you for cause. If there were other methods that could have been used short of termination for cause, that would have also allowed for the protection of the workplace. It's kind of fact specific. We got to look at all the factors of where exactly you worked. I'm not sure what LAUSD stands for. Maybe you can put that into chat. Los Angeles Unified School District. So Teresa, it seems that you're coming in from Los Angeles. So I practice law in Alberta, Canada, and so I can really only provide you with information on the law as it pertains to Canadian jurisdictions, mainly BC, Alberta, and Ontario. For anything related to the US, you'd have to contact a US attorney. Darren asks, I've worked as a grocery store part-time for 5 years. Am I owed severance if I'm let go, even if I'm part-time? Absolutely, Darren. It's not because you're part-time that you don't get severance. No, absolutely. If you're let go, you're owed severance. Basically, severance is often expressed in an amount of months. So, for instance, for 5 years, you might be entitled to 5 to 7 months of severance. And that will be based on your monthly average of what you were earning. So, basically your part-time salary for that 5 or 7 months or whatever it is. Figuring out how much severance you're owed is calculated using a number of factors, 4 main factors, which are your age, your length of service, the kind of job that you had, and the availability of similar work. We've simplified that to the extreme. We've created an online severance calculator that you can use at any time, 24 hours a day, to figure out what your severance entitlements might be. You have the website on the screen there. It's pocketemploymentlawyer.ca. pocketemploymentlawyer.ca. You just jump on that website, answer anonymously if you want. You can answer those 4 questions. We'll let you know what your severance entitlements are. It doesn't require that you put in your name or your email or anything like that. You get the information you need so that you know what your rights are. Dan Johnson asks, hello, I work for a federally regulated industry. I was put on unpaid leave as of February 1st to be terminated by May 1st without severance if I did not receive my vaccine status or get the shots. Last week of April, I got a registered letter from the company saying I was not terminated, but on unpaid leave indefinitely. Why the change of strategy with them? What are they trying to achieve? Can they keep me on unpaid leave indefinitely? The government did not change the law, and they said that they would. To make it mandatory to have vaccine policies. Does this affect them? So a lot covered in there. So there's two major components to your answer, to the answer to your question, Dan. Essentially, there's the business component and there's the legal component. So from a business perspective, I don't think it makes a lot of sense to be terminating all these employees who haven't gotten the vaccine. I mean, we're in a very tight, labor market. People need their staff. So I think that might be why some employers are taking their foot off the pedal of terminating all these employees. But more from a legal perspective as well, federally regulated companies are not necessarily required by the government to have their employees be vaccinated. So it's not like if you work for the federal sector itself, like for the RCMP or the government or something like that. These people are required by the government to be vaccinated. But if you work for a bank or a telecom company or a trucking industry, there's no requirement that you be vaccinated. So if the employer decides to pull the trigger and terminate you, then they're exposing themselves to severance. So they might be trying to forestall that. In terms of your second question, how long can they keep you on unpaid leave? Well, that's kind of your decision to make. They'll keep you on as long as you don't protest. If you do protest, if you say, I'm not accepting to be placed on unpaid leave anymore, pay me my severance, then you've put a stop to it. You'll be going after your severance, but you won't have a job to come back to. You'll be going instead after your severance. So you have to decide which is the best option. Do you rather wait and still have a job later on if the policy changes, or do you rather, put an end to this and get your severance and go after your severance? I have another question here from Speeches Beyond. I won my case for wrongful dismissal. Me and my employer both signed NDAs, but he said he can't stop his employees from saying bad things. If his employee is still talking rumors, is that defamation? So yes, it can be defamation, absolutely. Speechless Beyond. So generally, when you win a case at trial, there's no NDAs, there's no non-disclosure agreements that are signed. Generally, when a case is settled, privately that you'll sign a non-disclosure agreement. You're right, it is complicated for the entity that you're suing, which is the company that employed you, to guarantee that its employees will not speak poorly of you. But if they are, then that can expose them to a claim for defamation. Absolutely. Exists Outdoors asks, I was just terminated for invoking my right to refuse. I refused to work over 10.5 hours without breaks. Great question, Exists Outdoors. What are your recourses in that case? So if you're from Alberta, under the Employment Standards Code of Alberta, there are entitlements to paid breaks. All right. There are also entitlements to meal breaks. And so you basically told your employer, I'm entitled to a break. I'm not going to work unless you let me take my break, which is the law. You have to let me take my break. Now the employer decides, well, okay, Exists Outdoors looks like he knows his rights, and I don't want to have someone who knows their rights in my workplace. I'm going to fire him, teach him a lesson, teach her a lesson, not to assume, and give everyone else a lesson as well. Now, Exists Outdoors is just adding that they're from Ontario. So the law is the same in Ontario. You're entitled to paid breaks. You're entitled to lunch breaks. So essentially, you've been retaliated against because you've tried to enforce your rights under the Employment Standards Act of Ontario, your right to receive paid breaks. So actually, you now have an opportunity to make a complaint to the Ministry of Labor, saying that you've been the victim of retaliation. If the Ministry of Labor finds that you've been actually the victim of retaliation, as you say, the Ministry of Labor can order your employer to pay you back pay from the day you were terminated until the day they decide your case, which could be 5, 6, 7 months away, which could be a large amount of money. They can also order your employer to reinstate you, or if they don't order the employer to reinstate you, they can order the employer to pay you additional compensation for giving up your right to reinstatement. So there's potentially quite a bit of money on the line here. So definitely Exists Outdoors. I think this is one where you'd want to contact us, see how we can help you go after your back pay and your reinstatement rights for having been terminated in retaliation. So Exists Outdoors is adding that it was all done over text messages, so you have it in writing. So yeah, definitely get in touch with us. Actually, you can go, get in touch with us, and we'll help you navigate this issue so you can go after your severance. You can reach out to us again if you haven't noted the website. It's employmentlawyer.ca. Employmentlawyer.ca. We'll be happy to discuss with you your rights, either under the Employment Standards Act of Ontario, of Alberta, of BC, your entitlements to severance, if you've been terminated, and anything of that nature. Exists Outdoor adds, there's lots more going on. I'd love to talk with you further. Absolutely. If you'd like to speak with me, just tell the people when you reach out to us that you'd like to have the consultation with me. We'll set that up, and we'll help you. We'll help you on your way here. Absolutely, Exists Outdoor. I'd be happy to speak with you. All right. So another issue that has arisen in international news. Now, international news, of course, has limited impact. As I was saying earlier, the law is quite different from country to country, including employment law. So the law from the United States will not be the same as the law from Canada, or in this case, Spain. Essentially, Spain has created a leave that allows women that are going through menstrual pain to be able to take paid time off work. So the debate has been over the last week is whether this should be allowed, be it in Canada, in Ontario, BC, or Alberta. So it's an interesting development, one that I think should be followed. Of course, definitely, we want everyone in the workplace to feel healthy and to be at their best if they're doing work. And so if there is an issue where they're being handicapped from being able to do good work, and they do need some time to convalesce, that's definitely something that we, I think, should encourage as a society. The question, I think, will be, the great debate is always, will it be paid or unpaid? I have to say that in all provinces in Canada have a lot of leaves of absences that can be invoked under the various Employment Standards Acts. Most of them are unpaid. Most of them are unpaid. So we'll see if anyone picks up on Spain's trend, and whether they allow for these leaves to be paid, which I think would be ideal, of course, because the fact is, it's hard to miss 2 or 3 days work every month if you're not being compensated. Videoland is asking, in addition to pursuing severance, do I have a valid human rights claim if my employer denied my religious exemption to the vaccine? Absolutely, yes. So this is in Ontario. Videoland is adding. So there's a requirement that all employers respect the Human Rights Code of Ontario, and one of the protections in the Human Rights Code is the freedom to be free from discrimination based on your religion. All right. So if your religion doesn't allow you to get the vaccine, there are several reasons why some religions don't allow their practitioners to get the vaccine. And you communicate that. Of course, you have to communicate that you're asking for an accommodation from your employer. Then yes, basically the employer would then have an obligation to accommodate you to the point of undue hardship. So there's definitely a possibility to make a human rights complaint. In Ontario, there's something interesting, that while you pursue your severance in the courts, you can also pursue your human rights damages also in the same court action, which means that you don't have to start another action in the Human Rights Tribunal, which can really speed things up. So the Human Rights Tribunal is quite backlogged since the last few years. So it can really speed things up to be able to, piggyback your human rights complaint onto your severance lawsuit in court. Sarita Binda asks, please talk about being terminated during medical leave, but terminating not taking the vaccine, no severance given. All right. So I think I understand your question, Sarita, and my understanding is that you were on a medical leave of absence. While you were on a medical leave of absence, you were required to get the vaccine. Generally, when employers say that their employees are required to get the vaccine, they're saying that they have an obligation to protect the other employees, the customers, the other people that are on the work site. All right. So the employer doesn't have a very strong claim to require you to get the vaccine if you're not on the work site, if you're working from home, if you're on medical leave. What's the prerogative of the employer to require you to get the vaccine? So if they instituted a vaccine policy and required it of everyone, including people working from home, including people that were on disability leave that weren't planning on coming back anytime soon, that's a wrongful termination. So, and that could also be a discriminatory termination, terminating you while you're on leave. So that's definitely something where you have a claim for severance. Absolutely, yeah. So those are the clearest of cases. If you're not actually going into the workplace, how is the employer's objective of providing a safe workplace impacted on whether or not you have the vaccine? It doesn't make any sense. Absolutely. We have a question coming in from YouTube, from Facebook rather. Grace is asking, I've worked as a full-time employee for almost a decade. My company is going through some restructuring. I've been asked if I would be okay with becoming an independent contractor. Will this limit all my other rights? So basically, the only reason the employer wants to make you an independent contractor is so that you no longer have employment rights. All right. So there's a lot of savings that an employer gets when their employee becomes an independent contractor. They save on payroll because they don't have to deduct income tax. They don't have to deduct EI or CPP. They don't have to pay their share of the EI or CPP premiums. They no longer have to provide you with vacation pay. They no longer have to provide you with stat holiday pay. And generally, true independent contractors are not entitled to severance when they're terminated. So there's a lot that you're giving up here by doing that. I think it's very important that you consider this seriously and probably get in touch with us so we can talk to you about whether this is a good idea for you. I really don't think that it is. The other side of it is that now you'll have more burdens. You'll have to collect GST that you'll have to remit to the government. You'll have to prepare invoices. In some cases, you have to get additional insurance and things of that nature. So I personally think it's a lot better to be an employee than an independent contractor. Unless there's anything that they're offering you in terms of flexibility. An independent contractor, I just don't think it's a good idea. The more I think of it, I would not recommend that you go from being an employee to an independent contractor. I think there's not much at all in it for you, frankly. You get to keep your job for how long, and then you're signing away your severance, which if you've been somewhere for over a decade can be quite substantial. Absolutely. So there's a lot to think about there. I think you might, be signing away your right to a lot of severance in a company that's already not doing well financially, who might not be around for that much longer. So definitely something to think about very seriously. You might want to reach out to us to schedule a consultation so we can discuss with you the pros and cons. And you can do that simply by reaching out to our website here, employmentlawyer.ca. Employmentlawyer.ca will set you up with a consultation so you can speak with one of us. All right, Sarita, I think just put your question in again. So I think I covered that, Sarita. I think that, if you were terminated and you weren't going into work, you weren't looking to go back into work, you were on medical leave, if you were terminated for not getting vaccinated, I think you have a strong claim that you're owed severance. Absolutely. Let's see. So those are kind of the topics I wanted to cover today. We have another 9 minutes left on the show, so if anyone has anything they want to discuss, feel free to put your comments in the chat. We'll be happy to answer your questions, make sure that you get your employment rights today. Oh, Stephanie's coming in here. Stephanie Bush asks, my husband is a rigger crane operator for a construction company. In the past year, he was diagnosed with MS, which I take means multiple sclerosis, and he was even off for about 4 months due to a medical emergency due to his MS. His company recently laid him off and only stated that it was due to a shortage of work. We would like to fight this as he has been with the company for almost 10 years and sometimes doesn't just sit right with me with the situation. He's a guy who's never been written up, always shows up for work and gives it his all. All right, so what I'm understanding here, Stephanie, is that your husband, a very unfortunate medical situation, has developed. But for the purposes of your question, your husband has also been laid off due to what's the employer is calling shortness of work. Do you believe, Stephanie, you can put that in the chat, do you believe that the real reason for his layoff was his medical diagnosis? I'll wait for you to answer that question and get to that in a second. But even if it wasn't, even if it was a true lack of work situation, what happens is this: there is no right. The employer doesn't have a right to lay people off unless the employee gives them that right. The way an employee can give the employer the right to lay them off is basically two ways. So one way, there could be an employment contract, a written employment contract that the parties have signed that gives the employer the right to lay them off. Okay. Most employees and most employment contracts that I've seen in my career don't have such clauses. All right. So most employees have not explicitly given the employer the right to lay them off. The other way that the employee can give the employer the right to lay them off is to consent to the layoff through their behavior. And so usually how that's done is through past practices. If you've been laid off before, you didn't say anything about it, then you were recalled to work and continue to work, and still didn't raise your hand about the fact that you've been laid off, didn't protest essentially, then you've now given your employer, through the past practice of past layoffs, you've given the employer the right to lay you off in the future. So it's very important when you're laid off for the first time to think long and hard whether you want to give your employer the right to lay you off in the future. You have two choices. You can say, yes, okay, I understand. Times are tough. I'm sure he'll call me back, or they'll call me back in a little while, and then I'll go back to work. These things happen. Option two, though, is to say, no, I don't accept this. I don't accept that you can continue to say I'm your employee if you're not providing me with hours and you're not providing me with compensation, right? I am considering this layoff to be a termination. I'm going to consider this to be a constructive dismissal. Now you owe me severance. Okay, so that's my answer to your question, Stephanie. Your husband has to decide whether he wants to go after his severance, whether he's willing to say, I'm walking away from this job, I'm going after my severance, or whether he wants to wait while he's on layoff and wait to be recalled. So that's the option he has. That's a personal decision you have to make. But if you do decide that you want to go after your severance, or if your husband decides he wants to go after his severance, then reach out to us. We can help you secure your severance. If you're wondering how much severance he's entitled to, basically, like I said earlier on, we have a severance pay calculator. You can visit our website called pocketemploymentlawyer.ca. pocketemploymentlawyer.ca. We're going to ask you 4 questions confidentially about your husband, including his age, his lengths of service, kind of job that he had, and things like that. And then we'll let you know what we think his severance entitlements actually are, so that you have an idea of what we're looking at. I mean, and at the end of the day, this is all about, everyone's personal finances. If you're out of a job, if you're on layoff, you have to make important economic decisions, financial decisions for your family, and going after your severance is one of them. So you visit our website, we can help you get your severance entitlements if you are willing to go after your severance. Absolutely. All right, and if you have any questions that I haven't answered here today, if you want to get some information and you don't want to put it on the chat or anything like that to be read out loud, you can schedule a meeting with any one of our lawyers, absolutely. And we'll have a confidential attorney-client protected conversation with you about your employment rights, about any situation you're having at work, in complete confidence. So feel free to reach out to us. You can reach out at employmentlawyer.ca. That's employmentlawyer.ca, and we'll be happy to answer your questions. So once again, my name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I'm also the managing associate of our Calgary office here in Alberta. It was a pleasure speaking with you today about your employment rights. I will be back in 2 weeks, but we'll have shows all week next week. Join us again on Tuesday for another one of our shows. You can reach if you've missed a question or anything like that we weren't able to answer for you. We're on every day on Facebook and YouTube to answer your questions live. All right, we have one last question coming in from Antoinette McKinney. Hi, I was bullied and stopped. My God. Okay. Suffering with anxiety, and I was sacked for misconduct. I was going to put a claim in. So yeah, Antoinette, essentially what happens is awful things happen to us, and that results in physical or mental disabilities. Time needs to take time off, and sometimes we don't even recognize that we need help. And our work performance suffers. The fact is that it's not only on you to ask for an accommodation. The employer should have the foresight to connect the dots. The employer knows about your condition, sees that or about your situation, sees that your work is deteriorating. They have an obligation to inquire if there's a connection between the two. And if they terminate you because they refuse to make that connection, then that entitles you to not only severance, but human rights damages as well. So I'm not exactly sure from what you've described whether the bullying and stalking happened in the workplace, but it doesn't matter. Even if the bullying and harassment happens outside of the workplace but affects your performance at work, the employer has an obligation to inquire as to whether there's a connection between your performance and what you've been going through, and whether that requires them to provide you an accommodation because of the trauma that you're going through. Absolutely. Absolutely. So yeah, feel free to reach out to us, and we'll get more details. Obviously, I think there's a lot more to unpack to this story, but we'd be happy to help with your situation. So once again, thanks for joining us today. I appreciate all of your questions as always, and we look forward to seeing you again. I hope you all have a nice long weekend.